Hello and welcome to this podcast, which is part of a series called Inventing Embodiment. My name is Jonathan Burrows. I'm a choreographer and also a faculty member at the Centre for Dance Research at Coventry University. Last year, my colleagues at CDARE met online once a week to talk, and the conversation kept coming back to the question of how we speak about embodiment. This podcast aims to capture some of the research I was fortunate to hear then. My guest this morning is Charlotte Waelde, who is a former lawyer, now researcher at CDARE, where she's looking at intellectual property law in relation to intangible practices. Welcome, Charlotte.
Thank you, Jonathan. Really nice to be here.
First of all, did I get that right, or can you describe better what your particular areas of interest are?
I thought you described it very well. So if I start by just explaining very briefly, perhaps two of the current projects that I'm doing, that might put it into context a little bit more for the listener.
Great.
And how law starts to fit in with intangible practices. One of the projects that I've just finished actually, but we're still sort of writing up, was funded by the British Academy, and it has a very long title. It was called Celebrating Local Stewardship in a Global Market, Community Heritage, Intellectual Property Protection and Sustainable Development in India. And we called it HIPAMS for short. And what HIPAMS stood for Heritage Sensitive Intellectual Property and Marketing Strategies. And that's precisely what we did. We brought together an interdisciplinary project with heritage specialists, intellectual property specialists, which is me, and marketing specialists. And we worked with an NGO in Kolkata, and we worked with 3 marginalised communities in West Bengal. The broad aim was to help the communities think about how they could use their intangible heritage to make a sustainable living. And one of the communities that we worked with were the Cho dancers from Purulia. And Cho dancers use traditional dances and traditional costumes to explain and work through a whole range of traditional Indian stories. And then they also use traditional moves to narrate contemporary stories as well. So we worked with the community for around 3 years, helping them to think through how intellectual property and marketing might help them make a sustainable living. A second project that I'm doing at the moment is on pastiche and copyright. And copyright law has a number of what are called exceptions and limitations embedded within the law. And what these exceptions do is if you come under one of the exceptions, it means that you can use existing works that are protected by copyright law without payment or permission to the copyright owner. And pastiche is one of these. And pastiche has been fairly recently introduced into the law, and nobody really knows what it means. So I'm working with a network of pastiche artists and lawyers and other specialists, and trying to work out, or at least coming together to think what pastiche means from the artist's perspective and also from the legal perspective. And the hope is that we come to some sort of a view on what pastiche is that might help to inform the law as it develops into the future. And I'm very pleased to say that Sue Davies is a member of the network, because she's currently making a film with David Hinton, which uses pastiche as one of the techniques, which is a lovely film. And we're all looking forward to seeing it when it comes out.
So this podcast is about embodiment. And are there ways in which issues of physical embodiment are relevant to, or particularly at stake in terms of legal thinking around intellectual copyright and intangible practices?
I think in order to respond to that question, Jonathan, I first want to turn it back to you.
Okay.
And ask you what you think of as physical embodiment in this context.
Well, I mean, as anybody who's been listening to the whole series of these podcasts will know, there are so many perspectives on what embodiment is, what it means, what it gifts, what is problematic about it. I'm a dancer, I'm a choreographer, so I have a particular perspective. So I'll explain that, but I would emphasize that I don't think that this is the only possible perspective, and the other conversations I've had evidence that. But for me, embodiment in particular, the aspect of it that interests me is to do with slowly accumulated physical knowledge, which then contributes to a way of remembering, anticipating, and further imagining the world and how I move through it, and in terms of dancing or art making, what that might look or feel like. Does that answer your question?
Yeah, thank you. It did. And I do understand that there are many different ways of thinking about embodiment, and that my colleagues will think about it differently. Obviously, I come to this discussion and thinking about embodiment through a legal lens.
Yeah.
And most particularly, my expertise is around, as you say, around copyright law. And copyright law is a particular branch of intellectual property which encompasses two different types of rights, broadly speaking. One are economic rights and the other are moral rights.
Right.
And what the economic rights do is to give exclusive rights to the owner of a creative work. So the author of a book, or the painter of a painting, or the choreographer of a dance. And what these rights give to the author or the owner of the copyright are exclusive rights to reproduce that work once the work is actually fixed. So the book has to be written, the painting has to be painted, or the dance has to be filmed or fixed in some way, and then the owner of the copyright has the right to stop people copying it if they don't want them to. And the law does that in order to, well, it says it does that because it gives the author of the work this incentive to create more. So if you've got a right to stop somebody reproducing, you can charge for the reproduction, and that means you've got the economic incentive to actually create some more of those works. But when it comes to actually deciding what the legal rules mean, or adjudicating on them when people disagree. So somebody might say, but is that a dance work? Or is that actually a painting? Or is that an infringement of the work? Then the rules are objective. So the judges adjudicate on the rules, and the tests that they apply are objective. So if I give the example of deciding on whether copyright actually subsists in a dance, one of the requirements is of the work, of the dance in this case, is that it is original. But it's not original in the subjective sense. So it's not original in the sense that the dancer says it's an original copyright work. Yeah. But the judge has to look objectively at it and ask whether it's the author's own intellectual creation, and has the author made free and creative choices in developing the work. But those are objective. So the judge doesn't, if you like, get it inside, or the judge doesn't embody the knowledge that the dancer has around the dance. They look objectively and apply this legal test. What it means in a positive way is that judges don't have to interfere in decisions as to what is good art. The judges do not become the gatekeepers of what the art is, because it is an objective test. So in that sense, there's no physical embodiment by a judge in deciding whether copyright subsists in a dance. So it's not relevant to copyright in that sense. One could argue embodiment might be relevant to moral rights. Right. And moral rights originated in continental Europe, and they're rooted in the theory that a creative work is an emanation of the personality of the author. Mm-hmm. And two main types of moral rights, one of which is the right to be attributed as the author of a work, and the other is the right to object to the derogatory treatment of a work. Right. And although in the UK we interpret these rights really very narrowly, on the continent because the rights are seen as emanating from the personality of the author, they're much more likely to be included in an adjudication of whether one of the moral rights has actually been infringed. But I think one could argue that when it comes to moral rights, what the adjudicator, what the judge is doing is in some senses taking on this sort of embodiment of the work, or certainly the work in the way that the author has embodied the work and created the work from their personality. So it's, sort of, it's a little bit tangential perhaps to the way that you think about embodiment, but it's one in which the law might come together on these issues of embodiment with the way the dancer thinks about embodiment.
Yeah. So one last quick question to sum up this particular area that you're looking at, that you've just described. What would you like to see developed in terms of the relationship between copyright law and physical or intangible knowledge, or what are the areas that you have a question about?
Yeah, I mean, I mentioned at the outset the project that I've been doing in India with the marginalised communities and their intangible cultural heritage. And there is a whole raft of sort of international and national legal frameworks that regulate the area of intangible heritage. Yeah. And I think there would be a real step forwards for these intangible cultural heritage communities if the legal profession, or those who adjudicate on some of the really pressing and important questions that impact on these communities, actually learnt something about the embodiment of these practices from the communities, particularly given that intangible cultural heritage practices are embodied practices of living communities.
Okay, thank you, Charlotte. I could go on unpacking this with you in conversation for much longer, but I hope for anybody listening, this has really opened a door on a whole other way of looking at what embodiment is and what the impact of embodiment is. Thank you for sharing those thoughts with us today.
Oh, thank you for having me.
You're welcome.
Jonathan.